And I think that's the beauty of that. And it's just that simple. And I know that everybody that know how to do that is gonna get successful in this whole thing. It's their whole discovery process.
Facts.
Okay?
All right, y'all.
Especially if they put discovery.
We got 100
Yeah.
minutes on this recording. So I just started it. We got a couple more minutes, so we're gonna
Well, I
jump
want to
right
thank
into it.
Gladstone, Brother Gladstone, for coming forward with what he got, because I'm sure it's very powerful information. Because I mean, I had to get on here when I heard he was going to come on the podcast and that he was going to break down these truths and this reality for us. Uh, because he was talking about this whole chapter 7, and then he still got a house. I'm blown away. So I'm very excited to be here. I appreciate being here, and I just want to fall back now and listen to see what the brother gonna break down.
All right.
Too
So
easy.
welcome to the I'm Talking Business podcast. I'm your host, Eunice L. I'm sitting here today with the extraordinary, one and only Jah King
Mm.
El Bey,
That's
a
me.
Yes,
pillar
sir.
in
Amen.
getting results, putting in the work, and letting his work speak for himself. So we're not here
Mm.
just capping. We here 100% facts, and we're actually going to give you guys some results, so that you see that this ain't just talk. We're not just spitting out conversation and laws just to do it for hot air. We're going to show you that if you be diligent, you follow the script and stick to the laws, you can receive your remedy. So today's podcast is all about remedy with our special guest, Jah King El Bey. Jah, I just want to let the listeners kind of get to know you a little bit, what your background is, and how did you come to the study of law, and what has it done to change your life today?
Ooh, peace,
Peace.
peace, peace. Um, yeah, that's a loaded question. That last one, but I think there's a point in time you just get fed up, and you got the spirit of that pushback dude, and you trying to figure out what's this ain't right around me. So, anywho, that led me down a couple of different YouTube channels and finding uh gurus, self-proclaimed gurus, but it is what it is.
Right.
But it led me to the next chapter, the next degree, in my self-education. So, um, but as it pertains to uh, today's day, um, it's really easier than what we make it out to be in the beginning. So
Mhm.
I'm 8 years in now. Um, as far as the self-education part, as it pertains to law, so as it pertains to trust, contract law, um, now bankruptcy law, especially Chapter 7, um, but the entire public law. I'm getting a little better at. So whether it's Chapter 7, 9, 13, 11. So, um, but uh, but yeah, don't hold any degrees. I'm not here trying to tell anybody what to do. It's coming off personal experience, in and out of the courtroom. So I'll leave it at that for now.
I guess I want to ask on to piggyback on that. I mean, there's a lot of people listening out here that's going through some similar things, and they're at their wits' end. I mean, they figuring out what they're going to do, how they're going to move, where they're going to move, because they're at that breaking point where everything can just not work out for them, and they can work in a negative way for them, where they can be out here on the streets, you know. And what would be a recommendation that you would tell them in order to stop the proceedings and save them, and save themselves?
Well, what worked for me is I came across the federal rules of bankruptcy maybe 3 years ago, and it's just one of those. You have going through life and you find some good literature, but you're like, I don't have time for this right now.
Mm-hmm.
So let me just put it on the shelf. So that's what the federal rules of bankruptcy was for me. So at the time, I was still studying the federal rules of civil practice, civil procedure, federal rules of evidence, federal rules of criminal procedure. So, but I myself with my wife, of course. Our foreclosure process started in March of 2022. I sent my last payment October of 2021 to the service processor. And this is 2 months of them having an increased premium from when we initially attained the property up until that point. So I questioned it, and it's pretty much shut up and pay.
Okay.
Or get
Right.
out the house. That was the energy. So, once again, I'm a pushbacker. So the wifey was on board, my queen was on board. So I said, hey, let's go ahead and start these processes and let them know we're ready to go to court. So so here I am, September. I tried the 1099 process, as a debtor, as a creditor. I tried the stamp endorse send to the trustee, but when I finally put in for the bankruptcy, Chapter 7 to be specific, within a week's time, so what you have is something that they tell you to fill out. It's called a creditor's matrix, and you have to write down the name and address of each creditor that you owe a debt to, whether it's $1 or $1,000,000. There's also another part you have schedules that you have, which is part of your Chapter 7 process, and you have to list your assets. So home, automobile, clothes, pets, everything, solar panels, everything, the shovel in the garage. But the list of creditors, as soon as you file your petition, there's an automatic stay.
Now, for those who don't know what an automatic stay is, you want to elaborate what that means? That means the creditor's coming after me, ready to kick me out my house, and you file that Chapter 7, you got that automatic stay. What happens?
Every creditor that's on that creditor matrix that you completed and handed in to the clerk has to stop any attempts to collect the debt. If there's any court proceedings that are in place, that has to be stopped. If there's any judgments and they're attempting to move forward on a judgment, whether it's an eviction or a sale, that has to stop. So now, if you're already out the house, I think you can still include it, but I don't want, and you could possibly get it back, but that's 50-50. You really have to know the law and know how to move when you do that one. So,
Would that be
long
based
story
upon,
short,
would that be based upon their redemption period for their state when they can redeem the house back, or is that something separate?
Well, there is a redemption process in the Chapter 7 that I've gone through. Mm-hmm. So, and that's an option that you can use, but I'm not in that position, so I didn't have to use it. But if you can find out who the creditor is at that time of your filing, if you're out the house, then you could bring them back to the table, because at the end of the day, the whole purpose of the bankruptcy procedure is to get rid of any debt that you have, whether secured or unsecured.
Mm-hmm.
So, and if that's still reporting as a debt to you or for you on your credit report or anything like that, then you can list that. So as a debt, and that debt has to be resolved. So that means you should have the legal ability to move back in because you've taken care of the equity, or you have equity in the house now.
And let me ask this: while you're going through that process, is it only debts that's on your credit report, or is it also you can do the bankruptcy on debts that's not on your credit report?
Anything that you list on that matrix, that creditor matrix. So if it's on your report, not on your report, you think it may be on your report, you think you owe a debt, just put that company's name there and the best known address for them. And they'll be notified that you're in bankruptcy. And since you're in bankruptcy, there's automatic stay. So, yeah, I definitely want to get into the laws when you're ready. So,
well, you mentioned a couple of things there, and
okay.
You mentioned a couple of things there. You mentioned the snap endorse send method, And of course, there was really no way to determine if that really worked or not. But so based on what I'm hearing from you, as soon as you filed that bankruptcy, all bets was off. You put that
Agreed.
credit matrix in. It wasn't about no stamp endorsed sin. It's about understanding that the United States obligation is to discharge the debt. And one of the ways you have to go through to get that discharge from a bankrupt corporation is go through the bankruptcy court.
Agreed.
Wow.
So, and as far as the house is concerned, so with your Chapter 7 bankruptcy,
Wait, hold on,
you
hold
got,
on, hold on. That's the
okay,
big question. Don't want to cut your wisdom.
yeah, yeah.
That's the big question that most people want to know. The big question is, how did you keep your house while going through the Chapter 7? Because it sounds like that's what you're about to get into. So I want to set the stage after we come back from our break, because I'm going to break it right here. We're going to come back from our break
Pay some commercials. I
and
mean,
play some
pay some.
commercials and let our sponsors get a little shine, and we'll be right back. So y'all stay tuned. So boom. So that's how you do the podcast, right? So right now we just taping. I'm gonna edit it out and I'm gonna cut that out and then put the commercials in and all that type of stuff. And then boom, we go to the second stage. So you want to take a sip or something? You need a break?
Nah, I've been sipping.
Okay, okay. All right. So I'm gonna come back and bring it back in. I'm gonna say, and then we can continue going forward with the big question of how you kept the house. So I'll introduce that, then we can move forward on that. All right. All right. So welcome back to the podcast. I'm your host, Eunice Sadan L. And today's guest is Jah King El Bey. And after listening to Jah King El Bey, I'm thinking that he's one of the coldest out here if you got a bankruptcy situation, if you need to discharge your debt. And we're going to show you, we're going to get the information how to get a hold of him for your questions and concerns at the end of the show. So definitely get your contact information together at the end of the podcast, so you can get people that want to reach out for you for your expertise. And of course, it ain't free, guys. There's a donation involved, so this man's knowledge is worth every penny. So I want to thank you for coming on to the show. So let's get back to the big question. The big question is, people want to know how in the hell was you able to keep your house after filing for Chapter 7 bankruptcy? Because most times people get liquidated and they have to get out of the house, right? And they end up losing everything, not knowing because why? You don't read the law. So bless the people with the law to tell them a little bit of information how they can keep their house.
Absolutely. So Chapter 7.
And you're reading from where?
So, and bankruptcy. Right? So in all of your assets that you have, the list, bank accounts, investments, homes, that favorite scarf, your favorite jersey, you got to list it all. And then what happens is there's a trustee that's hired by the court that steps in and acts on behalf of the creditors. And his job is to get a list of all of your possessions. If you have life insurance, you know, everything that you have. And then his job is to liquidate those things and pay off the creditors that come to the creditors hearing. So that's on your schedule A and B, is where you list all of your assets, your properties, cars, everything. So, and then you have something called Schedule C. Your Schedule C is where you put your exemptions. So, depending on how you file, as far as exemptions go, you have federal exemptions and you have state exemptions. So, sometimes your state exemptions are more liberal and profitable for you. It allows you to keep more equity in your secure debts. So, whether it's a home, whether it's an automobile, if it's a motorcycle, anything that's secured, you can keep a higher amount of equity if just sometimes your state allows for a higher level of equity for you to keep compared to the federal homestead exemption, or home exemption rather. So, um, but another thing that the bankruptcy law is designed to do is for you um, to have a fighting chance after all your debts are settled to rebuild your life. And the way they do that is if you have 5 homes, they'll let you keep 1 home.
Mm.
If you have 20 cars, they let you keep 1 car. And I believe it's the same rule if you're married. So the only difference in the rule when you're married is you keep more equity.
Mm.
And once again, it depends on your state. But what you're allowed with the at least the Chapter 7 um, bankruptcy filing is they allow you to because of homes the home exemption, you get to keep 1 home and you get to keep 1 automobile.
So let me ask you about that 1 home and 1 automobile. Is that something that's done once in a lifetime, or is that something that's done more than once throughout your lifetime?
Well, I believe once every. I'm
10 years?
not sure if it's 7 or 10 years
I think I heard 10.
that you can file for bankruptcy with the same tax ID number.
So y'all hear that? You can keep a car, 1 house, okay? Because most people lose that, right? And you was studious enough in the law to pull up the law to show where you can keep that because they didn't volunteer that information.
So here's another thing. So the court appoints a trustee, right, to work for the benefit on behalf of the creditors.
Mm-hmm.
And what they do offer, if you're a pro se litigant or petitioner, is a pro se attorney that you can go to, and they can look over your paperwork for you, okay, and make sure that you filed everything correctly. Um, that's to save the time of the court, of course, back and forth with paperwork. So some are great, some aren't, so, but we were blessed because we had someone who looked over our paperwork and we missed one thing, and they helped us correct that and get it on the record. Um, so I guess my point in all that is saying the Schedule C is very important.
Mm-hmm.
And that's where you put your exemptions at. So if it's oh yeah, by the way, solar panels. So we have solar panels on the house, and we're able to keep those as well. So because they're looked at as an attachment to the house, so you just add it into the value of the house, so it's not a separate item. And then 1 automobile. So yeah, so
Hey man, that right there in itself uh, is huge for the average person that's going through bankruptcy because they always feel that they need to do a 13 or a 7. But let me ask you one question that me kind of rewinded. You said something about how you file your taxes. What if you don't file taxes? How does it work at that particular point?
that's that's not a beat against you. You can actually also discharge through the bankruptcy petitioning process federal tax,
Okay.
and of course state tax and city
Hold on.
taxes.
Let me mute this. Let me mute. Follow. Let me mute real quick. All right, he muted. Appreciate you, brother. Welcome to the podcast. All right, go ahead. G.
So did you hear that about the tax?
No, you said that you can discharge the tax through the Chapter 7.
Correct.
That's strong. What about okay? So you can discharge pretty much any debt that you list on that Schedule C, right? No matter if it's state, federal, private, you can discharge
Anything. Absolutely.
because that goes back to what we've been learning, guys. 18 USC 8, the all debts or obligations of the United States, especially federal debts and taxes, and your home. I mean, did the company? You said they had to come to the meeting. What was that like when the creditors came to the meeting to learn about this bankruptcy process? How did that go with the creditors?
So just like a regular court case, they have to put notice that they'll appear, right? Notice of appearance, right?
Mhm.
So so two of them so far have signed up. It's BMW and it's the law firm that has been assigned the mortgage. So from MERS, well, it went from MERS cross country to cross country, and then cross country assigned it to the law firm. So, but at the creditor hearing, you get to cross examine them.
Mm.
Okay, so that means, of course, you want them to swear in, just kind of like any other type of cross examination. You want to ask for their bond, you want to ask for their bar card. So they should have so it's not just federal bar card, but it's also, they have to be appointed to the bankruptcy. They have to know bankruptcy law. So you could get all this on the record. Of course, you need their bond just in case they cause you any type of damages. So you have to be able to lien their bond. So you could demand that. Also, know if you go in as a pro se litigant, the trustee is there to bamboozle you.
Mm.
So be ready for that. Nobody's your friend.
Ooh, that right there, that is a jewel. Everybody feels like the attorney that's appointed to them is going to be on their side, but the trustee is there to bamboozle you, to make sure that you lose your assets.
Right, because the trustee gets paid off of your assets. So the more he can liquidate, the more he gets paid. And then on top of that, he said, 9 times out of 10, they're all part of the same boys club, bar, and all that. So, he's getting, I can only imagine he's getting more money just to get you out of the way.
So here's
So
the
they,
big question: how did you find out that the trustee was there to bamboozle you?
um, once I found out who the trustee was, I sent an email, and in the email, I started asserting positions, through questions,
So you
you
wasn't
know,
using your attorney at this point. You was using your own knowledge.
correct, straight out of so public law. So this is public law 95 through 598,
Public Law 95 through 598.
and that's the 92nd statute. So that's just right out of Congress, the 95th Congress. Okay, and this whole thing talks about the law of bankruptcy, which created the codes.
Ooh.
So get that. So law before the code. So whenever I'm putting my paperwork in, I'm coming from the public law and not the codes or the statutes.
Let's
Okay, and
let's
you'll
not downplay what you just did. You did something because I think people may have missed it and thought that you may have been working with an attorney in a
no.
sense, right? He went into bankruptcy without an attorney on his own knowledge, without an attorney, went in, got his debts discharged through a Chapter 7 bankruptcy, and kept his house. All by knowing a lot. I mean, like you said, he's been in the study game for 8 years, but the main thing that he's giving you is the public law that governs the bankruptcy process. So I encourage you guys to read it, understand it, and comprehend it. My bad, bro. Go ahead. I didn't mean to cut your
Nah, you
wisdom.
good. You great, man. When I go on tour, I know who to hire.
No doubt.
Nah, that's dope, brother.
Mhm.
So, okay, so I'm going to go back to, I think one thing that's so powerful is the automatic stay in regards to any bankruptcy. So, whether it's a 7, whether it's uh, a 9, 11, a 13, a 15, it's interesting, those odd numbers, right?
We're gonna get that
Anywho,
public law. Remember, we're gonna everybody who came to the webinar gonna get the audio recording of the webinar, so it'll be in the webinar. Go ahead, brother.
so in the chapter 7, right, out of the public law,
Mhm.
so chapter 7 is liquidation. So once I go there, there's a powerful section. Um, where is it at? So you have section 344. If I was y'all, I'll write that down.
All right, so get a public law again if you got it in front of you, and then we'll get the section. Matter of fact, let me write it down too. All right, you say public law 95.
95 through 598.
95 through 598.
That's the 95th Congress, and that's the 92nd statute.
Statute.
Okay, so, and from that public law, Title 11 was born, right? Bankruptcy. All right. And remember, these billion, trillion, $1 million companies do this every day.
Yeah.
As far as bankruptcy is concerned, and just reorganize and open another shop up, right?
Right. Let me mute Cal. Welcome to the
So,
podcast, my brother.
Peace, God, peace.
Go mute real quick so we don't cut the bill.
Mm-hmm.
You mute your phone? Can you do it? Go ahead.
Hold up. I'm trying to figure it out.
Think I got you. All right, go ahead. Go ahead, bro.
So you got section 362, okay, of the public law, and that's concerning automatic stays. Okay, so automatic stay is just that. It's automatic. So it's like an injunction. It's an estoppel. Nothing can move forward from this point. Okay.
Okay.
So it says a petition filed under section 301, 302, or 303 of this title operates as a stay applicable to all entities. So now 301, that's if you're doing a voluntary chapter 7 liquidation. Okay, that's if you're doing a voluntary one. Okay, 302 is if you're doing a joint. So if you're married, or it could be two business partners, filing for the business. If you're doing a joint, and 303 is involuntary. Okay, so if you were forced, of course, to do a bankruptcy petition. So the automatic stay, regardless, it covers. So it says the commencement or continuation, including the issuance or employment of process of a judicial, administrative, or other proceeding against the debtor that was or could have been commenced before the commencement of the case under this title, or to recover a claim against the debtor that arose before the commencement of the case under this title. So there's an automatic stay, okay? Whether it's a judicial process proceeding, administrative, or anything. So when you hear that, so any court issues, whether it's a traffic ticket, whether it's building permit violations, whether it's a foreclosure, and you're in state court, city court, federal court, it doesn't matter. There's an automatic stay. So I had 5 lawsuits in the that I was being sued for from credit card companies. 5. Automatic stay on all of them. So what happens? They file for discontinuance without prejudice, which means they can't come back. Okay? So the only way they could get their money is if they show up to the creditor's hearing. Okay? Otherwise, they got to stop any and all collection processes, phone calls, letters, and each time they violate, you can send a letter to the judge. You don't have to. You can go ex parte if you want to, but you don't have to, because at the end of the day, it's just you and that trustee. Okay, so as long as you keep that trustee in check, you're good to go. Just subrogate your business, handle your business, let them know you age of maturity, and whatever needs to be discharged, let's go ahead and discharge it. But you also want to let them know that whoever shows up and they can prove that they're the creditor, that you're the beneficiary and the investor of that security instrument, and you want your money. So that's another thing that you can set up too when you meet with the creditors, and they can prove that they actually are the true creditors.
Before we go to our next break, I want you to tell the people how you handled the trustee, and the trustee came back with an apology letter.
So in the beginning, once again, as soon as I filed and I found out who the trustee was, So I filed September 7th of this year. So 2 days later, I get an email notice from the court saying who the trustee is. So I sent out an email to the trustee. Always keep a paper trail, and introduce myself, who I was, and then I asked him if he was the trustee. Do we have a trustee beneficiary relationship, or like a attorney client? So he was emphatic. He said no.
Right.
I work for the creditors. I don't work for you. You're not a beneficiary. Oh my God, he was talking some smack. I was like, okay. He drew a line in the sand. At least I know where we stand, right?
Mm-hmm.
So after that, I had my initial hearing set up for
Was that the
10/13.
presumptions and assumptions that you did?
So I just filed that. What's today? Thursday. I just filed that yesterday.
Okay.
So I did that for both cases.
But
So
that lets you know he wasn't on your side once you sent them questions.
correct.
Okay.
So after that, I had my initial hearing set for 10/13, and before the hearing, they wanted a bunch of paperwork from me. Like your copy of your ID. So because of course they're gonna try to securitize it and the whatnot, and they want to be, because you already handed that information in when you did your petition. You see, so why would they need it again? Okay, he could easily go to the clerk of the court and get all that, right? Why would he want a copy of all that all over again, right? Anyway, so the hearing was for 10/13. He wanted my paperwork by 10/9. I contacted him 10/9, and he automatically sent me an email saying that you didn't show up. So we're gonna adjourn, and then we're gonna move it back to November 9th. The hearing, and make sure you get the paperwork in. So I was like, all right, cool. So got a couple more days. So I went to go hand in some other paperwork for that case, and then lo and behold, he filed for a dismissal of my bankruptcy petition.
Try to stab you in the back.
But for not showing up to the creditors meeting that he adjourned. So I was like,
That he adjourned.
Yeah. Okay. So so there's that. So of course, okay, now it's time for me to buck back, right? So you go into the same public law. There's section 5, okay, and that tells you about the trustee's job, okay.
Woo!
So, and you make sure that he's acting correctly. So,
fiduciary duty of a trustee. Boy, go ahead, bro.
So and everything's in the public law. And remember, always come from the public law. Do your best. Try not to come from the codes and statutes. Okay? But, wherever you at is where you at.
Hey, the people in the chat, please jot down some questions, because we're going to open it up to questions, because we're on the timeline here. So if y'all have questions, know what y'all questions are going to be, because if you have any, we're going to open it up, because the brother dropping some science, and I know y'all got to have some questions. Go ahead, brother.
So let's see. I'm trying to find, but at the end of the day, part of the trustee's job is to, or qualification rather, is to be competent. So I sent a letter. Well, I objected on the record. I put in a notice of objection, and my reason for notice of objection was the trustee's incompetence, and how that was his only duty, or qualification rather, one of his main qualifications, to be a trustee, and he shit the bed. So I put in the public law that said that, and I put in all the emails that he sent me as evidence, Exhibit A, Exhibit B. And then the next day, once I filed that with the court and sent the judge a copy, the next day, he emails me a copy of what he filed in response, saying that he apologizes. He filed the notice of dismissal in error. So at the end of the day, was I right? So the judge is going to see this dude's an idiot.
And just for the record, I'm gonna read just one or a little bit of the legal definition of incompetence. It says incompetence or incompetency usually means a lack of legal ability to do something, especially to testify or stand trial. Incompetence can be caused by various types of disqualification, inability, or unfitness. Someone who is judged incompetent by means of a formal hearing may have a guardian appointed to the court. Sometimes the sole disqualification age is in the case of minors, and I'm not going to read anymore. And the popular usage of incompetence means a general lack of ability or qualification to do something. And that's what he did in that letter.
Agreed.
So, with that being said, you have successfully kept your solar panels as an attachment, kept your car, kept your house. Everybody, a lot of people has filed Chapter 7 bankruptcy and been liquidated 100% just to wash the debt. So you was able to keep it simply by reading the public law 95-598, 95th Congress, what is it? 95th Congress, 598-92. I guess I might be saying that wrong because I write sloppy. But at the end of the day, I'm gonna go back and listen to this again. And you gave so many jewels in this whole podcast. And what I want to do now is, you got anything else to add to it? Because I think you shared a hell of a lot of knowledge.
Nah, let's unpack what we talked about. If there's any questions, there's questions. If not, I'll get in the background and listen.
All right, so I want to open the floor up for questions. All you got to do is unmute your phone. If you got any questions, let's go ahead and open it up. You guys got any questions? All you got to do is unmute your phone. Or, matter of fact, let me unmute everybody. I think everybody unmuted. Okay, Eugenio, you unmuted. Everybody should be unmuted. Nobody got any questions? We good?
No, I want to congratulate the brother, man. For doing the good work.
Sure.
So public law 95. Hold on a second. Just took some notes. 95 to 98.
95 to 598.
Okay, 95 to 598. Okay.
Can you see it?
Yeah, 598. No, I don't have it all in front of me, but I'm writing it down. So
Absolutely.
So that whole public law talks about the duties of the trustee and the fiduciary, right?
The duty of the trustee. So, and he's acting as a fiduciary. He's acting as a fiduciary, but not for your benefit. So it says for the benefit of the estate. So that's how you're the beneficiary. So
Right.
it's that's why it's very important. So actually, section that is section 700. Well, sorry about that. Yeah, so it's section 701, offices and administration. And that goes into the interim trustee, the election, how they elect the trustee. So this is where you could check them and be like, where's your bond at? Okay. Mm-hmm. So, because if he injures you or damages you, you got to go for liability. Okay.
Thanks.
So it has the duties of the trustee. It talks about what happens at the creditors committee, dismissal, so there's only certain ways he could dismiss something. So like when he tried to dismiss my case on the low, the only way you could dismiss it is for unreasonable delay by the debtor that is prejudicial to the creditors. So, I said define unreasonable. That was all in my objections, under penalty of perjury, under oath. Define what that means and what body of law are you coming from by saying that, so you got to check them. So I don't know if I answered your question. I get off topic a lot.
No. My question, because that happened to me with Capital One. they had sold the debt to a third party. I sent a third party debt collector to the third party, and eventually they ended up taking me to court. And when I went to court, I asked the judge, where was Capital One? Um, that the third party couldn't speak for Capital One, and that I didn't owe the third party any money, and originally they had said that they were going to adjourn the case, right? But she said, this is what the judge said. So we're gonna go ahead and
What type of court were you in, Eugenio?
small claims, I believe.
Okay.
Um, so the judge told me that she was going to adjourn the case, and she said we're going to adjourn it for next month. This is what she told me, right? So I go home, and I'm thinking that in a month I should get a correspondent, for the next case. But what they did was they scheduled the case 2 days later, and I never received the correspondent until 2 months later, and it was in the mail. And it was funny because it didn't have like the U.S. Postal stamp or nothing like that, right? It kind of looked like somebody just put it in the mail.
Is the case still open?
Well, what they did was they charged it off, and they have it as a charge off. But now what I'm trying to do is basically um, do the same thing that you did, which is talk to the trustee and get the dividends and all that other stuff. But
Well,
they told
I've heard about that process, but I haven't seen any success with it for myself. So I'm not telling you to do that.
right. So we work. I'm working. I'm still learning.
We all
Um,
are. Shit. Once you say you arrive, you dead.
so what I called Capital One not so long ago, and I asked them, um, for the original contract.
Your
And
best bet. I'm sorry to cut your wisdom, but your best bet is either find out who the general counsel is
mhm,
for Capital One, and start a conversation there. Okay.
mhm.
So that to me, that's going to be your best route because the general counsel has liability for the organization, for the company. So they're going to send your letter or your information or your conversation to the right department. Okay, especially when you let them know that they got the liability for the company.
Okay,
So
what's the name again?
general counsel, just find out who
Gen.
the general counsel is for that division of Capital One. I don't know if Capital One is in other countries, but and then all
They
your
made.
communication should be to them. Excuse me, sorry. And then email works great. Don't sleep on emails. If you can
Yeah.
find their emails, email them, and just put the Paper Reduction Act. That's why I'm emailing you, you know.
Mhm. Right.
And then once you get their physical address, then you can start, getting things on the record. But at the end of the day, if they don't act right, you got to be ready to go to court. And the only court that you can really get justice in, I believe, is district federal court. So you got to get into some. If you ain't already there, that's that's gonna be your remedy. I'd go through my suggestion. That's what I would do. I go to
So
general counsel.
let me ask you this question, because in their contracts they have that you can't put it in regular court, that you have to go through arbitration, you know, in order for you to I guess get a remedy, right? That's why
Mm-hmm.
a lot of people get 12B um, for
They get their stuff kicked out. Yeah, failure to
for
state a claim.
failing to state a claim, because in the contract it says that you can't take him to court.
But here's the
Uh,
thing. Now they already started moving on you, though, right?
right, absolutely.
Okay. Did they try to arbitrate with you?
No,
All right. So why you being a nice guy?
No, I ain't trying to be. I ain't trying to be. Yo,
No, I'm not trying to, bro.
I
I'm not trying to hit no egos and none of that. I'm just
It's
saying,
just
don't be
it's
a
chess,
nice
Eugenio.
guy.
It's chess, baby. It's
yeah,
chess.
no,
Yeah.
I know. That's why I'm asking the questions because, um, you know, the thing is that I'm trying to get the original contract, but they're telling me that they sold it to a third party. But then when I called the third party told me that they don't have
So,
no such contract. You know?
Yeah, it's securities. Are you familiar with securities?
he is.
Yeah.
So as soon as you autographed it, it was securitized.
Mm-hmm.
Okay, and once that happens, they insure it, then they sell it more than once. You
Right.
know,
But
and
no, but they
go
don't
ahead.
want to give me. They don't want to give me the
No,
information
He said
no,
because
that
the third.
they
he's
look
gonna
at you
get
as a
you.
they look at you as a ward. You know, like you're incompetent, like you don't know the law. That's how they look at us.
Mm-hmm.
Okay, that's why we gotta assert ourselves.
Right.
Okay, otherwise, once again, presumptions. They're presuming that you're incompetent. They're presuming that you're a ward, like you don't know what you're talking about. You know,
Mm-hmm.
so that's why I learned from Jonah Bey. You know, all roads lead to court. You know,
Absolutely.
Shout out to
so
the salute to the guy.
so you I should either leave it alone, but if you want to go after them, I would go that route. I
Well,
would contact.
I don't want to leave it alone because they're affecting my credit now because they what they did was they charged it off, and I tried many tactics to try to get the charge off, and they take it off and they put it back on. They
They sell
continue
it
to
back. Yeah,
Do they give you a notice before they put it back on, Eugenio?
no.
Okay, so they violated a part of the Fair Credit Reporting Act, but you could take them to court for that because they are supposed to give you notice. That's why all roads lead to court. You got to take them to court. That's your only remedy.
Right.
They
yeah.
can't.
But
Right.
I would start writing the general counsel, and that would be my going. You know, that's the
Right.
person I would communicate with, and whether he communicates or not, I don't care because I want to take him to court for damages. You
So
Right.
see?
administrative process them, and then, like you say, default judgment. And then if they don't do the default judgment, then you get punitive damages, right? That's the way.
Yeah, because they violated the arbitration clause in the beginning when they started moving against you um, adversely, without attempting to arbitrate with you.
Right.
So that's part of your due process. But on the commercial administrative side, arbitration is the due process part. So
We
Yeah.
good?
yeah.
No.
Any other questions? We good? That's it?
Yeah.
But
That's it.
do you got is that the only thing that you got on your credit report?
Well, I got Capital One. I got a few others. I got like four of them.
You got a house?
Not yet, but I'm looking towards getting a property, very soon, and I
Okay. What
can't
about a
move
car?
forward.
You got a car?
I got a car, yeah.
Okay. You still owe?
No, that's paid off.
Dang. I'm
It's
like,
paid off.
stack the deck. You know what I mean? Hey, big companies do it. They run up their credit, file
Bankruptcy.
for bankruptcy.
Yo, we see it all the time, man. We see it all the time. 50 Cent did it. Donald Trump do it. Everybody did it. You know,
what
it's
what I'm
Business.
what I what I'm trying to do right now is just get the charge offs because that's the only thing that's holding me back. Because after that, then my credit is going will shoot up because I have a lot of good uh right now I have four accounts and those four accounts are pretty high. So
See,
um
so if you got, I don't know how you do business, but if you got another EIN or ITIN or something like that, I'll probably transfer ownership. Get it out of the if it's in your personal social, and then
no,
anyway, let me stop talking about this.
well no I don't because just like you I follow Jonah and I don't have nothing in my none of my business in my personal. I don't have it tied to that. So I'm just trying to clear the credit so I can go ahead and buy
Well,
myself an investment property. That's all.
I filed September 7th then on my tax ID, and it already went up 100 points. So
Boom. And that's another thing about bankruptcy. People got a misconception when you file bankruptcy that your credit's going to be in the toilet. But he just said he filed in September, and it's what? The end of October, his credit went up 100 points.
yeah.
That's
Oh, and
amazing.
another thing is there's a fallacy out there saying that you can't discharge student loans.
Hmm.
That's true to a certain extent. Now, once if it's a federal loan, of course, then if the servicer has been assigned the loan and the servicer becomes the debt collector, that's no longer so. Normally, you can't discharge in a bankruptcy like alimony, child support. Um, what else? Oh yeah, if you got a murder charge, I think if you got a murder charge, you can't get rid of that. So, but student loans you can, especially if a servicer has been assigned the note, and he's the one taking first position as the collector, as the debt collector. Then it could be discharged.
Okay.
So just a side note.
Yo, Jah
What I
El Bey. I want to thank you for coming on the I'm Talking Business podcast. You have enlightened the people. You got to understand, this is going to go out to the world of the U.S., United States of America, and let the people know how they can get in contact with you. You got an Instagram, you got Facebook, however you want to be contacted. Put that information right out right there because I guarantee you, you're gonna have a ton of people reaching out to you when this podcast drops.
All right, dope. Too easy. Appreciate it. Let's
Yes,
see.
sir.
Uh,
Gotta let the God shine.
it's the Instagram. Hold on. Yeah, here it is. The Instagram is teaching principles without the vowels. So that's
Spell
T. So
it.
you know I'm bugged out. Yo, so that's T-C-H-N as in Nancy, G. That's teaching. So without the vowels. So no A-E-I-O-U, right? That's the vowels they taught us, right?
Real language.
So that's teaching, T-C-H-N-G, and then principles without the vowels. So P-R-N-C-P-L-S. Teaching principles without the vowels.
At, and where's that? Is that Instagram?
Oh yeah, that's Instagram.
All right, so at teaching principles without the vowels at Instagram.com. Is that pretty much it?
Yeah, I'm peace. I appreciate your time, man. Appreciate the questions.
And I want
And
to say
best of luck to everybody.
I want to say
let,
peace to the
let me
gods.
get
Shout out to the ancestors that give us the opportunity to come together in this forum. And God bless. And speak to the God.
hold on.
You got something else?
Yeah. Does the brother work with charge offs?
You work with charge offs?
Nah, only as a discharge, or through the bankruptcy process. That's it.
He's a bankruptcy expert.
Okay, got it.
I mean, that's not a bad move to go bankruptcy, but you got to make that choice for yourself. I mean, he's filed bankruptcy in September. It's already October. His credit score went up 100 points. He got his house. He got his car. He got his solar panels. Sounds like bankruptcy ain't so bad. Now, the
Yeah.
other thing we want to touch on before we go is the income portion of it, which I don't think we touched on that because you said that at the time, of course, earning no income. So let the people know how they can distinguish between the income and the compensation or whatnot, or even if you can elaborate on that, I'm not sure.
Right, absolutely. So in I chose chapter 7 because I don't have regular income. Okay, that's why I chose chapter 7. There's another option. I think it's 13. Yeah, so chapter 13, if you have regular income, like every week, every month, every year, you know what's coming in, whether you a W-2, salary, whatever, you got a guaranteed amount. If you have a regular income, then I would suggest chapter 13. So it's almost like if you've heard of the process of consolidation when you have debt, so if you have 10 different debtors, you get them all at the table and you work out one payment. So that works the same way with a Chapter 13 bankruptcy.
But tell them how you can challenge. Because most people think you can't challenge certain things in the Chapter 13.
Absolutely. So any chapter that you file as it pertains to bankruptcy, the creditor has to prove how you owe that debt under cross-examination. Don't forget that. So who's going to show up is the question, and be held to answer questions under cross-examination, under oath. How do I owe you this debt? How was the debt created? Are all these things you can
The
ask them.
discovery
So
questions. Did you do discovery questions
correct.
Okay, so he did his discovery questions during his hearing, and guess what, guys? He didn't fall up under the jurisdiction or the incompetency of getting an attorney because he had to ask questions that maybe that attorney is not going to ask for him.
Absolutely. So once again, I'm a pro se litigant.
Pro se litigant. Let's not get it twisted.
So so you have the trustee that's there that's pretty much steering the conversation, but there's another point I wanted to tell y'all about. It's immunity. So the same way this Fifth Amendment works, where you don't have to say anything that's going to incriminate you. There's a law when you're cross-examining and when you're being asked questions that you don't have to answer any questions that's going to incriminate you, or cause the debt to be what I'm looking for, authenticated.
So incriminate yourself by your own admission, but you have the right to remain silent. So some cases could be left up. When things are remain silent, how does the judge move on there if you don't say anything back and forth? How does that go?
Well, you could adjourn and come back. Mm-hmm. You could take a brief 5, 10, 20 minutes. So, but you have that power to not answer a question, especially if you're not speaking the same language. You can question their terms. Where do they get their terms from? And once again, they're supposed to be under oath as well. Mm-hmm. So 9 times out of 10, they're not going to be. But unless you challenge, then you won't have that easy victory.
And you said something right now, and I was supposed to end the podcast, but here we go building again. But you said something about the terms that's very important. It's very important about the terms. Now, the definition of the terms. Did you come into this case and define the terms in the beginning, or did you allow them to define the terms?
You have to define the terms, and you have to put it on the record before the hearing starts that you do reserve the power, the power to question them on anything that you don't comprehend. Okay. So, and as long as you put that on the record before the hearing.
Did you give them time to object to the terms that you gave them?
7 days.
And they did not object.
No.
So he went into the court defining the terms based on what he said things are going to be, and they didn't rebut the terms. So therefore, those definitions stand in his case when it comes to his claim.
Mm-hmm.
That's solid, guys. So go in there and define the terms, do the presumptions, the alphabet of presumptions and assumptions, defining the terms. It sounds like to me what he did was something that we should do in the beginning of every single case that we're dealing with. Come in with your presumptions, denial of assumptions and presumptions, definition of terms. All right, then you control in the court at that point. Basically, at that point, I mean, that's what I'm hearing from.
Yeah, you'll get a default judgment in your favor, or if it's a regular case. But like the God said earlier, as far as just moving for discovery on everything. So if they don't give you discovery, that's if you're a defendant. But in this case, thank God, thank the ancestors, thank the universe, I'm the petitioner, so I got the power.
You got the
power as the executor and the beneficiary, over that tax ID number.
That's fact.
So, man, you just gotta assert your position.
Yo, Jah King El Bey, I want to give it up for Jah King El Bey. This is a hell of a show. A hell of a show. A lot of information was dropped tonight. I got to give 100% props. A lot of information was dropped tonight. Y'all asked some great questions. And I want to thank y'all for tuning in on Talking Business Podcast. Stay tuned for the next episode. I'm Talking Business with your host,
Peace.
Mr. Don L. And get in touch with Jah King El Bey if you got any questions about bankruptcy. That's peace to the gods, salutes to the gods, and thank y'all for tuning in. Peace.